Hello, and welcome to NACM's 2021 Annual Conference Video Bonus Sessions. On behalf of NACM President TJ Bement and President-elect and Conference Chair Kathy Griffin, welcome to today's session. NACM would also like to acknowledge the generous support of the State Justice Institute for their support of this and all the programs of the annual conference. We would like to thank the Conference Development Committee for creating this educational programming for 2021. My name is Jude Del Prior. I'm a former NACM president and presently assist the association in education planning. With me today is Erin Carr, NACM Association Manager. Today's program is being pre-recorded as a bonus to both live and virtual conference attendees. Our presenters have provided their contact information that will be uploaded and posted with this video in the event you have questions after viewing. Today's session title, we want to hear from you, putting court user voices to work. Inviting feedback from court users and then putting that feedback to work can be challenging for courts, but well worth it. This session will explore the concrete efforts of 7 pilot courts to collect and utilize court user feedback as powerful tools for change and enhanced fairness. Our presenter today is Emily LaGratta, JD. She has led dozens of procedural justice pilots and training interventions in courts and other justice agencies around the country. Current efforts include a National Court Voices project seeking input from court users and court staff about 12 pilot courts' pandemic responses. Past work includes To Be Fair, We Want to Hear From You, a toolkit for collecting and learning from court user feedback, Procedural Justice in Action, and Measuring Perceptions of Fairness and Evaluation Toolkit. After serving as the Director of Procedural Justice Initiatives at the Center for Court Innovation, Emily started LaGratta Consulting in 2019 to focus on helping local and national agencies design and implement innovative programming that boosts trust building and better engages participants and community. Emily, it's all yours.
Well, thank you so much, Jude, and all of NACM for the opportunity to talk with you all today. As you could hear from my background, I'm crazy about the topic of finding creative ways that courts and other justice agencies can engage the public. And I'm here to hopefully make a compelling case to you that there's really never been a better time to invest in these efforts. So thank you to NACM. Thank you to the State Justice Institute. As you'll hear, they actually have been the primary funder of a lot of the pilot efforts that we're going to talk about today. So I'll second Jude's appreciation and gratitude to them as well. So let's dive in. So this topic to me is really grounded in some of the core purposes of what courts are trying to achieve. And so often when I talk about these topics with courts, I ask them a question like, what words do you want the public to use when describing your court? So think about that for a minute, right? Many courts have mission statements or vision statements. And I think probably some common words might come to mind, but how do we want the public to see us? And hopefully that aligns pretty well with those stated missions. So a recent time when I asked this, these were some of the words that these court professionals chimed in with: judges, court clerks, other court personnel. And the bigger the word, that meant the more votes it got, right? The more people who identified this word as a hopeful descriptor for their court by the public. And so we see things like respectful, helpful, fair, knowledgeable, being among some of the most core values that we hope the public sees in our courts. And so, not surprisingly, perhaps, these words are very consistent across all audiences. Courts across the country, when I ask this question, give very similar answers. And lo and behold, that's because, in fact, there's a research basis. These are words that, in fact, all human beings expect of authority figures, including our courts. And so the more we can lean into these specific dimensions and make sure that we have targeted strategies to show the fruits of those labors, I think we're boosting then the delivery on these core purposes day in and day out. So many of you, I'm guessing, are familiar with the concept of procedural fairness. I like to root it in this broader concept of fairness overall, right? And there are research-based building blocks of fairness. So while fairness certainly includes fair decisions, fair outcomes, which is largely the effort of many lawyers and judges, what many law review articles and appellate decisions are written about, fairness also must include a discussion of fair treatment. How does the experience, how is it the experience to the court users coming through our doors? And that's where we don't have to guess or wonder as to what people are expecting or what they want out of that treatment. Procedural fairness or procedural justice literature gives us a roadmap and gives us those key components that most people are most likely to identify as the building blocks of fair treatment. And so those are respect, voice, seeing unbiased decision-making, and understanding, or you might also see that as demonstrating trustworthy motives, depending on which research studies you read. And so the reason that this is so central to conversations about hearing from the individuals we serve is it noticed that voice is one of those central pillars. So the more that we can find ways to engage those voices, right off the bat, we're advancing the fair treatment aspects of our work, and likely learning along the way as well. So what do we think? Do court users think we're fair? Many of the courts I've been lucky to work with have made significant investments in procedural fairness through training, through pilot efforts, evaluation measures. And one of the trickiest things I've noticed over the years is that few courts actually have a great method of answering this question on a consistent basis. We're making all of these investments of time and effort, but is it making a dent, right? Is it making a difference? Do court users think we're fair? Which really is fundamentally the only way to get at that dimension of fair treatment. We need to ask people. We need to ask them directly. So I started looking around at other sectors. The justice system, the court legal world, we're a complex animal, right? But many other sectors have tackled these similarly complex questions. And so once I started looking, I started seeing invitations for voice everywhere. I saw it in a follow-up email from Teladoc, perhaps not surprising. The health industry, I think, has been looking for patient input and feedback for a number of years. I saw it in a follow-up after a customer service call with American Express or with my bank. But then I started noticing it in perhaps some less likely locations or engagements. My children are New York City public school students, and I noticed that I got a school experience survey each year asking about how we're doing. And there was a sort of intro video making a case for how important it was for parents and other caregivers to weigh in on that and provide that feedback. And so I started to see that all of these other companies, public sectors, they're making this investment in collecting voice. And so where it really hit me is I have a picture here of an airport restaurant in Costa Rica, back when we all used to go places. And there was a simple feedback stand asking about my experience interacting with their staff. And I thought, if this small restaurant with two employees on shift at a time, serving food in an airport, if they're getting value out of a simple feedback mechanism, then certainly our industry can figure this out as well. So, of course, let's be realistic. There are plenty of obstacles to getting feedback. I've heard many of them over the years as I've talked with courts about what some of the barriers are to collecting feedback. One of them, the feedback will mostly be negative, right? Our jobs are plenty hard enough. Why would we want to invite an onslaught of criticism or negative feedback? And that's a very real concern. I've also heard it's too expensive or too labor intensive. Many courts have experience conducting larger scale studies, perhaps even partnering with an outside institution like a university to conduct a study. And it's a big ordeal often. And so there's a little bit of that, that memory of past experiences that it didn't go well, or it was so intensive for our staff. On the flip side, I also hear that, we're going to go through all this effort and no one's even going to provide feedback. And so there's also that, feeling that we won't be rewarded for our labors in this way. And then last but not least, I heard from many courts that they're not sure they would know what to do with the feedback even when they got it, right? This is a relatively new concept for us. So if we go through the trouble, and even if people share it, what are we going to do with that information? How do we make it actionable? So I knew that if we were going to try to take this on with some pilot courts, some sort of leaders in the field who are willing to try this out, I knew we needed to tackle these obstacles head on if we ever had a hope of getting a broader group of courts to invest in it. So as a concrete set of examples of the concern about that concern number one, that the feedback will mainly be negative, the reality is that even courts are already getting feedback, whether they're asking for it or not. You can see here on the bottom, I have a Yelp icon, I have a Google review icon. So even if you're not directly asking for feedback of court users right now, they are likely volunteering it. So after this webinar, one of our action items is going to be, go Google your court or your jurisdiction and check out what that feedback is. And I hope you'll be pleasantly surprised to see that it's going to be a complete mix. They say about these feedback kind of contexts that they tend to be very extreme. So you can choose to take that with a grain of salt. But I can all but guarantee that you will see the positive mixed in with the negative. So these, what I'm sharing here are real life feedback items from a court that I won't name, but they struck me as fairly representative when I've worked with other courts on this as well. So it's a mix, right? One says it's a total pain getting in and out of this place. Others start to be a little bit more constructive. They open at 7, but you can't use any services until 8. That's, I think, a pretty sympathetic item of feedback that we can all imagine what the rationale for it is, but how that reality may be perceived. A bit of good feedback. Someone said, tough job. These folks are working pretty hard to do it right. Nice work. Right, so all of these people took time out of their day, tracked down a way to provide this input without frankly knowing whether it would fall on deaf ears or what might come out of it. So you can start to imagine the potential of when we actually strategically request feedback in the ways that we know would be most helpful to court leadership and staff. So the point is, feedback is inevitable, and it will be a mix of good and bad. And so that was one of the things that we wanted to, again, see if we could create some parameters so that we were getting the most productive or constructive feedback as part of our pilot projects. So that other obstacle about, that other obstacle about it'll be too labor intensive. So many of the courts, as I mentioned, might have had a feedback, a suggestion box. Or here there was a simple survey outside of one courtroom looking for information about experience in a small claims court. And what we heard is that it's no one's job to collect the forms, or the person who used to be gung-ho about this project moved on to another role or to another court. And so again, these efforts seem to sort of rise and fall, maybe with the individuals championing them, because it's an extra job, right? It's an add-on that now requires all these mechanics to put out paperwork, collect them, and then actually do something with the information that's collected. And most court staff that I've talked with don't have the extra time sitting around where they might be, able to build a spreadsheet and input the dozens of details that they get back via these surveys. So that was another one we wanted to try to tackle. And so the picture began to get clearer, and that to really give voice to court users, right? To give them an opportunity to give feedback to the courts, but also to equip courts with a way to really measure some of these fundamental goals, including fairness. We had to find the sweet spot of what feedback do clients actually want to give us, right? What are they willing to tell us? What feedback would be useful to us, right? And that may not be a perfectly overlapping set of things. And then last but not least, what's feasible, what's low cost, what's low burden? Because if it's not those things, it'll feel like a luxury. It'll feel like something that really courts can't sustain over time. So I'd like you to give this a try right away. This is a way that we can engage, even though we're you'll be viewing this asynchronously. So get out your smartphone and open the camera function. Most of us have experience with QR codes at this point in the pandemic. But if you hold your phone up, the camera app up to this QR code, it should prompt you for a simple URL or website you can go to, and it'll ask you, has your court collected feedback from court users lately? And I'll be really curious to see those answers as they come in. So I started looking for kind of off-the-shelf, user-friendly opportunities for courts to employ some of the technologies that I'd seen in other spaces. My guess was that technology was going to help us on that efficiency front, right? To let a computer of some sort do the heavy lifting of organizing data, presenting in a user-friendly way. And there's a lot out there, frankly. You may have seen the little emoji, smiley face kiosks. I actually just saw one in my local post office yesterday. But I wanted something that was adaptable enough, frankly, that we didn't require court users to put things in terms of smiley faces. There are lots of serious matters that are handled in our courts, and the suggestion that anyone should come out smiling might not be set the right tone. And so I looked for platforms that would have options of maybe using pictures as part of a way to give feedback, but that also provided other question formats as well. And so what I found is I ended up partnering with a particular software company that really offered a range of feedback that mapped onto all the different ways that courts interact with court users. And amazingly, in this early planning, this was in 2019 when things looked a little bit differently. But even then, I knew that some courts were starting to use email, or some courts were driving a lot of traffic to their websites, for example. And so, boy, were we happy when we had those formats in place when 2020 came along, and so many more courts were using other, virtual and other remote methods of communicating. So we had those ready to go. But the most sort of standard, especially pre-pandemic, was thinking about how do we grab feedback from people within the courthouse. So a tangible device, which looks like the one shown here in the screen. So this is from one of our pilot courts from our initial pilot last summer. And as opposed to expecting someone to stop and spend 20 minutes clicking through, 45 questions that we may have of them, the idea here is we want to grab their attention in maybe 2 minutes of their time. So have some sort of enticing question where they're going to be invited to provide their input. There might be a follow-up question or two, but it's not a kind of settle in and answer a complete survey. It's really this short and sweet feedback. And so we thought about across all the unique, courthouse settings, what are some places where we might put this? Here's an example of one that was right out the door, capturing feedback from people leaving. We've tried it where it's outside of a particular courtroom, so you could get feedback that then could be overlaid with the type of hearing or certain staff that were in the courtroom at the time. So you can really start to get more specific information that helps us with that sort of utility piece of the puzzle. So the thing, as I mentioned, one of the things that was really interesting to start to play around with were some question formats. So we could ask closed-ended questions, which certainly felt most comfortable for court leaders initially, meaning that it was a closed universe, right? Someone couldn't type in things that then the court may not know how to respond to, or there were concerns about court users disclosing something about an active case. And so the closed-ended questions, like the one that I showed on the previous screen, or here's an example using the emoji, people were sort of contained and had to choose one of the offered items. Thumbs up, thumbs down, etc., yes, no. And you'll start to see that among the questions we were asking, we were trying to get right at those performance measure aspects of fairness. So this one, for example, did the judge and court staff treat you fairly today? Gets right at the heart of it. That can be a scary question to ask, but it's so fundamental. And as we'll talk about, the results were quite encouraging. So among the options, we tried a whole range of questions, including drilling down into specific elements of fairness. So if you'll recall those 4 elements of fair treatment or procedural fairness, they touch on respect, voice, neutrality, and understanding. And so we had phases within our pilot where we asked specifically about that point. So here's an example asking about respect. And again, we knew based on where the feedback was collected, for example, individuals leaving the clerk's windows or individuals leaving a courtroom, we knew for the most part which experience they were reflecting upon. So unlike a traditional survey where everybody's feedback goes into the same pot, and you may not really know what their most recent interaction was, here we knew that with relative certainty. We played around with different multiple choice questions, which allowed us to get a little bit more nuanced in some of the things we were asking. How could we be better? How could we improve our service? Here's an example of one where you may have noted that many of the questions we asked in 2 languages. Our pilot was in Texas, where in most locations, Spanish was a high or a close second in terms of languages spoken by court users. And so the conditional formatting of the questions actually allowed us to let people opt in to answering all future questions in just Spanish. So you'll see here that last multiple choice option would allow them to do that. So conditional formatting essentially means that we can create the feedback tree of follow-up questions based on how they answer the original one, which again gives flexibility that many paper surveys wouldn't. And then by the end of our initial pilot and already into our new Court Voices project pilots, we're seeing that courts really are feeling brave enough, frankly, to ask open-ended questions and reap the benefits of that, right? So many questions, especially when asking about things where the court genuinely doesn't know, right? How have our pandemic responses been going for you? What have been the barriers? We may not be able to best create the multiple choice answers that would get us rich feedback in that way. And so open-ended questions are a great opportunity to do that. And so we're starting to see more use of that option as well. And then last but certainly not least, the format then also can prompt someone to go talk to a human, right? We all have had interactions with technology where really you just want to talk to a person. And so here we were able to talk with each court so that the sort of final conclusion page could connect them directly with the right person, whether it was to ask for a supervisor or courts that have an info desk, for example. Again, they're sort of, it's completing that feedback loop in case this sort of technology interaction left the person wanting to, ask follow-up questions or share additional feedback. So to drive additional traffic to the kiosks, which we knew would be a concern, and we just wanted to see how much it could boost our response rates and the volume. Some courts chose to also put signage up around the courthouse, right? They could let people know, we want to hear from you. Even if the people didn't end up providing feedback, this is delivering a clear message to all court users that the court is valuing their voices. which in my mind is giving us a boost on one of those fairness elements. And of course, you could pair that simple sign, with a QR code that sends people right to the same experience. So for the germaphobes out there who we were worried about even 2 years ago, and now I think all of us have additional cause for concern, here's a way that you can answer the same questions in the safety of your own device. So here's another opportunity. If you want to pause the presentation, get out your phone, you can actually link into a demo of some of the questions that we're considering for current and past pilots. So you can go ahead and try that one out. It's different than the one we tested earlier. QR codes also give other options in terms of placing those on written communication. So for example, big topic right now among many courts I'm working with is what to do about non-appearance rates. To the extent we knew why people maybe didn't come to court 2 years ago, I think now that has gotten to be a more complicated analysis, especially as court services have changed and certainly people's lives have changed. So if your court has a routine way already of mailing out, court date reminders or notices after an initial incidence of non-appearance, that would be another great way to grab some targeted feedback from those individuals about why not they may be planning to come to court. So the other big obvious opportunity to collect feedback is online. And again, this is, sort of exploded in the past year and a half due to pandemic responses. And so what was nice is that we were able to basically all in one place have similar questions being asked, but in different formats. And so this is a screenshot of an email signature of a court clerk in a municipal court in Texas, where in their reply to court users, maybe assisting them with a question about the hours of operation of the court, or replying to them after a virtual court appearance, maybe with some follow-up paperwork. Embedded right in the email signature was this one-line question with feedback buttons that when they clicked into it, they've already provided their feedback. And there'd be some additional follow-up questions if they chose to share more. But this one click kind of grabbed that initial impression of their experience, much like the tablet option would have had they appeared in person. And so the same format, because it's really just and I've learned a lot about technology that I certainly never thought I would, but it's really, it's just a hyperlink, right? And so that's something that then you can put these icons, or even just the website URL. You could put that at the end of a Zoom or WebEx hearing. You could put it on your website, anywhere where court users are communicating with the court in that sort of digital way. You can invite them to weigh in via a format like this. So again, there's really now kind of almost a dizzying amount of options in terms of how we can grab that just sort of initial read from people. We're also testing out some of the features of having alerts. So this is a screenshot of my phone where we can set it up so that individual court professionals could be alerted if there's a particular response from a particular device or some other method, which would be really helpful if you're getting a type of feedback that requires an immediate response. So perhaps someone leaving a courtroom and not understanding what's next or how to get the assistance they need. You could imagine a scenario in which staff could be deployed to respond in a certain way. So remember back to one of those obstacles we flagged, which was that, even if we ask, no one will give feedback. And that was very much a concern, certainly as we were launching this in the summer of 2020, when volume was pretty low in courts. Operations were turned on their heads, and we just weren't sure whether the public would be willing to touch a public tablet, right? Or even to, kind of interrupt their busy day for even 2 more minutes. And so we were pleasantly surprised, blown away, in fact, that across our 7 courts, in just 3 months, almost 2,000 court users were able to weigh in and provide feedback to those courts. It ended up being mostly in person, so mostly in that kind of tablet context that we showed, because that was the one that most courts employed. 6 of the 7 courts had in-person foot traffic during the pilot, but still a quarter came through via the email signature route. So both seem to have utility, especially for interactions like an email, where that may be the only interaction they're really having with the court. For courts that ended up kind of creating that channel to even resolve cases and certainly ask questions and the like. And again, signage and things like that, we think likely gave a boost for those numbers. So the final bit of obstacle, which we were very hopeful that we would be able to tackle, is making a case for how this feedback is actually useful to court leaders and staff. And so remember that at a minimum, we gave voice to 1,900 court users that may not have felt otherwise that the court valued their feedback or was interested in some of the insights that they shared. So at a bare minimum, we've achieved that, right? We invested in one of those building blocks of fairness. But beyond that, we got some pretty good actual data back as well. So across the 7 pilot courts last year, and this certainly goes against the myth as well that feedback is mainly negative, 82% of people replying to questions about fairness and the elements of fairness, 82% gave a thumbs up to their courts, 90% via email. So really, this started to serve as a reinforcement that this really could be a way that courts could start to have fairness be included as a performance measure, right? That we could track this over time and ensure that we're keeping this at a high level, or maybe even elevating it. Another thing that we didn't expect but was extremely welcomed is that once the courts started to invite open-ended questions or open-ended feedback, almost all of the open-ended feedback that came back in was positive. And in particular, much of it named specific staff members or specific experiences that served as a huge morale booster for those staff, especially in a time when it was really hard to be a court professional. So you'll see here one of the examples. Someone wrote in, "I got my first violation, which is really embarrassing, and specific staff member helped me out with no judgment." Or, "Since I couldn't leave work or wait on the phone, certain staff member was very gracious to communicate with me through emails. She did her very best getting me information on how to help, etc." And another person said, "Wonderful folks in a thankless job." It's really hard to capture things like this beyond just anecdotes, right, in our work. And so you could start to imagine, though, that if you had a way that it was a routine practice of collecting feedback back like this, it could feed into staff performance reviews, right, to commend and recognize the staff that really are delivering on this aspect of the court's function, right, of helping court users to feel fair. So the other way that we're hoping that it will be useful, and we're trying out right now, as was covered in the introduction, is we want to see how we can actually use this sort of live feedback to help inform policy and practice decisions. My guess is that regardless of when you're watching this, your court is still needing to make very difficult decisions about how to move forward from the pandemic response practices that have been implemented recently. Should we keep Zoom? Yes or no? For what types of cases? What additional supports are needed for staff in order for this to go well? What supports are needed for court users to make this go well? All manner of priorities in terms of health and safety, etc. So this is another way that we think that by inviting in the voices of those most directly impacted court users and also court staff, we're going to have much more rich information to serve up to the court leaders that are making these very difficult decisions. So that's another way that we're testing to see how that feedback can really be, actionable right away to inform those changes. So the last thing I wanted to cover on the pilot is, I remember when I was a practitioner, I'm a lawyer, I worked in a very busy New York City court. And if I would have heard a presentation about something like this, I think I would have thought, this sounds fancy and like something we can't afford. Because often it felt like we could barely afford, pens. So I wanted to just kind of clear that air and provide an outline of what it does cost in pretty specific terms, just so you can, factor that into your analysis of how appealing this may or may not be for your court. So in our pilot and with the software company that we ended up working with, this is literally pennies for people's thoughts. So, there's a software dimension for both collecting in-person feedback and remote or email feedback. If you do go the tablet way, obviously you have to have the tablet. But really all in, if you were to have both an in-person feedback opportunity and a remote feedback opportunity running consistently for an entire year, it would cost you about $900. So that's not nothing, and not every court has that at their disposal. But you can start to imagine really what you could potentially get out of it, especially if you just were to try it out for a few months and see if it's something that maybe you could do on a on and off basis going forward. So I hope some of you feel intrigued enough to explore more, maybe dig a little deeper and think about specific questions that you might want to ask of court users or even court staff, right? Or other stakeholder partners. It's certainly not limited to court users. It's just that's where I think there's potentially the biggest gap right now in past efforts. And so much of our process from the 2020 pilot in those 7 courts is documented in a toolkit. It's available for free download on my website, which is LaGratta.com. The URL is there at the bottom of the screen. And we've attempted to capture how you might walk through and make a case for doing this, how you think through what questions you might want to ask, what you might want to get out of them. And then it shows some samples of the types of actual data that we did get back from these 7 courts. So kudos to again, to SJI and to the Texas Municipal Courts Education Center, who was the sort of lead partner on that. So I encourage you to check that out as a next step. Also, as I alluded to earlier, as some sort of to-do items, if this has piqued your interest, I really do encourage you to Google your court, Google your jurisdiction, and check out those Yelp and Google reviews. Will it be representative data? No, right? It's a smattering of folks who sort of self-opted into providing feedback in that way. But my bet is you'll see something in there that'll surprise you in a good way, meaning that it'll offer a perspective that maybe you hadn't thought of. Because especially the folks who have been doing this work a long time, you are experts. It's really hard to get that fresh perspective on what some of the things are that may be serving as barriers or assets within your court context. The second thing is ask around about whether your court has collected feedback in the past. The answer may be that it hasn't, but if it has, you can explore what worked well, what were the barriers locally for you, because that's going to give you some clues about what you're going to need to solve if you're going to try this again in a new way. And then similarly, maybe your court hasn't made a recent effort in this. Again, ask around, why not? Because you will need a sufficient amount of buy-in from the relevant players before you embark on this. And so listen for what their concerns are. Maybe there'll be some of the ones we discussed today, but if not, you'll want to work with them to tackle them and gain comfort before you are to kind of baby step into trying something like this. And then last but certainly not least, use the toolkit. It is designed to help you, make that plan to try this out, however small scale. It could just be try it out for a month, see how it goes, or perhaps you have bigger ambitions. But it is designed to do that, and to the extent it leaves open questions for you all, please reach out, and we'll be happy to try to fill in some of those details. So before we wrap up, I'll just leave you with a number of resources on procedural justice or procedural fairness. One, because I think it's a topic well worth investing in, whether you're going to go the sort of, trying to hear from court users directly or not. This is still sort of a well-established dimension of high-performing courts and really a core function of our courts as well. But it will also provide you fodder for if you do, begin a project like this. Much of these resources are going to, dovetail and might give you ideas for questions to ask or other resources that could supplement these efforts. So there's a great website called proceduralfairness.org that has a whole host of practitioner resources, research. There's a blog that you can sign up for. So if you're not already familiar with that, I encourage you to do so. And then, of course, as I mentioned, my website includes a number of the things too that I've helped to produce over the years on this. So whether it's training or self-assessments and bench cards and things that start to go out into other, nooks and crannies of court engagements, like, community forums and the like. There's a ton out there. So please, I hope those are useful to you as you continue these efforts. So I'll wrap up here. I appreciate you tuning in. Please drop me a line if this is of interest, if you have questions, if you have concerns about it. This is a very much an emerging topic. And so every conversation that we have, we're going to, advance the ball a bit and learn from one another on this. So please stay in touch. I'd love to hear how you're putting some of these practices to work locally. Thank you.
NACM would like to thank Emily LaGratta for an excellent presentation today. And thank you for those of you tuning in today for viewing the program. Remember, if you have any questions or desire additional information, you may contact Emily directly. Aaron, it's a wrap.